A permit holder can walk into thousands of businesses across an entire state today and be standing on completely different legal ground than they were standing on 1 week ago, and almost nobody explained to them exactly why. On June 25, 2026, the Supreme Court ruled 6-3 in a case called Wolford versus Lopez, and it rewrote the default rule for carrying a concealed firearm into any private business open to the public in the state of Hawaii. Here is the part almost no one is talking about. This was not a ruling about whether guns are allowed in Hawaii at all. It was a ruling about something much quieter and, honestly, much more consequential day to day. Who has to speak first, the gun owner or the property owner, when nobody has said anything about guns one way or the other? That question just got answered by 6 justices, and if you carry a firearm anywhere in the country, you need to understand the reasoning behind it, because it did not stay contained to Hawaii for long. And understanding exactly how this case worked its way to the Supreme Court tells you a lot about where the next legal fight is likely to happen. Before I break down what the court said and what it means walking into a store today versus 2 weeks ago, hit subscribe, because this reasoning is already being cited in challenges to similar laws in other states. Tell me in the comments, when the law is silent about guns on private property, should the default protect the owner's unstated preference or the visitor's right? That is the actual question this case answered, and it is a genuinely harder question than most people assume once you sit with it for more than a few seconds, because both answers sound reasonable until you have to actually live inside the legal framework that follows from picking one over the other. Let's go back to 2022 for a second, because you cannot understand this ruling without it. That year, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen, and it created what is now called the historical tradition test. Under that test, a modern gun regulation only survives if it is consistent with the way firearms were actually regulated at the time the Second Amendment and the 14th Amendment were adopted, not whether a state legislature today thinks the regulation sounds sensible. Before Bruen, courts across the country generally applied a balancing approach, weighing a state's public safety interest against the burden placed on gun owners. And under that older approach, states had far more room to justify restrictions with modern policy arguments. Bruen swept that balancing test away entirely and replaced it with a much stricter historical inquiry. In the aftermath of Bruen, states responded in very different ways. Some loosened their laws to comply quickly. Others, including Hawaii, went the opposite direction and tried to rebuild restrictive frameworks using language that technically fit within Bruen's new test, at least in the state's own view. Hawaii's law said that on private property open to the public, a business, a restaurant, a shopping center, carrying a concealed firearm was presumed illegal unless the owner had explicitly given permission. Silence was treated as a no. That sounds like a small technical detail until you realize it meant a permit holder walking into an ordinary grocery store with zero signage of any kind, zero stated policy, was legally in violation the entire time, just by virtue of the owner never having said yes out loud. Now, here is where the ruling itself gets interesting, and this is the part that got buried under vague headlines. Justice Alito wrote the majority opinion, and he did not soften the language at all. He wrote that Hawaii's law was presumptively unconstitutional, and separately, that it unquestionably imposed a new and significant burden on the exercise of the right to bear arms. Read that second phrase again slowly. The court is not saying the burden was debatable or minor. It is saying, in a formal legal opinion, that requiring affirmative permission before a constitutional right can be exercised on ordinary public-facing property is not a small inconvenience. It is a significant burden, and burdens like that have to clear the historical tradition test, which Hawaii's law failed. The majority opinion also directly addressed the practical dynamics of how a permission-based system actually plays out for ordinary business owners, noting that even proprietors who genuinely have no objection to permit holders carrying might still avoid posting a welcoming sign out of concern for how it looks to other customers, creating a kind of silent, informal chilling effect on top of the law's formal one. That observation mattered to the majority's reasoning because it meant the burden fell not just on gun owners navigating uncertainty, but on the entire structure of how rights get exercised when the default itself does the discouraging. The state of Hawaii, for its part, argued that the opt-in default actually served property owners better by giving them a clean, predictable baseline, rather than forcing every single business to make an affirmative decision about firearms policy whether they wanted to or not. The majority rejected that framing, finding that predictability for the state's preferred outcome does not outweigh a demonstrated burden on a constitutional right, especially when the historical record does not support treating silence as prohibition in the first place. 3 justices dissented, so this was not unanimous, but a 6-3 majority is a decisive binding outcome, and as of June 25th, it is the law. So what actually flips on the ground? Before the ruling, if you were a concealed carry permit holder traveling to or living in Hawaii, you had almost no reliable way to know if you were breaking the law just by entering a business, because the default ran against you everywhere, silently, constantly. After the ruling, that presumption reverses completely. Now you are presumed allowed to carry into any private business open to the public unless that business has posted a clear notice or told you directly that firearms are not welcome. Picture a permit holder who flies into Honolulu for a work trip, has never carried in Hawaii before, and stops at a convenience store near the airport. Under the old rule, that stop was a presumed violation unless the owner had specifically said carry was fine, which virtually no small business owner had ever bothered to declare. Under the new rule, that same stop is presumed lawful unless there is a posted sign. Same store, same person, same firearm, completely different legal status, purely because the default direction of the law reversed. Now picture that same traveler a week later, stopping at a different location, a private members-only club that has posted a clear sign at its entrance stating firearms are not permitted on the premises. That posted notice is exactly the kind of affirmative statement the ruling says property owners are entitled to make, and ignoring it after the ruling carries the same legal consequences it always would have. The ruling did not eliminate a property owner's ability to exclude firearms. It simply moved the responsibility for making that choice explicit onto the owner, rather than leaving it as an unstated background assumption. If you carry in Hawaii, your action step is to start watching entrances the exact same way you already do in states like Texas or Florida, looking for a posted notice rather than assuming you need pre-cleared permission. There is a second layer to this that most coverage skipped, and it matters more than the Hawaii-specific outcome. Because Wolford versus Lopez was decided using the Bruen historical tradition test, the same reasoning applies to any other state that built a similar opt-in default after 2022. A handful of states wrote laws structured almost identically to Hawaii's, treating silence as prohibition rather than permission, often passed in the same legislative window as Hawaii's own law, as part of a broader wave of post-Bruen legislation aimed at preserving as much restrictive authority as each state thought it could defend. Those laws are now sitting on thin legal ice, because a state cannot credibly argue its rule survives a test that just struck down a nearly identical one, especially when the reasoning in Wolford versus Lopez was this direct about the burden an opt-in default creates. If you live somewhere with a comparable law, do not assume it is still standing just because nobody has challenged it yet. Your action step is to actually check your own state's current default rule, rather than relying on what you remember from a few years ago, because in a handful of states, that memory is now outdated. There is also a boundary here worth being precise about, because this ruling did not reach every category of restricted location, and treating it as if it did could put a permit holder in real legal jeopardy. Wolford versus Lopez addressed private property open to the public, ordinary businesses like stores, restaurants, and shopping centers. It did not touch separate categories of sensitive places that states can still restrict under long-standing historical tradition. Places like courthouses, polling locations, and certain government buildings, none of which were part of this case and all of which remain fully enforceable. So while the legal presumption at an ordinary business flipped in favor of carry, that flip does not extend automatically to every kind of property a permit holder might visit. Treat sensitive place restrictions exactly as you did before this ruling came down, because Wolford versus Lopez narrowly reset one specific default, not the entire landscape of where carry is permitted. Step back and look at the whole shape of this. For decades, the legal default in plenty of places quietly assumed that silence protects the public from firearms. The Supreme Court just ruled, at least in this specific context, that silence has to protect the right instead, and the burden shifts to whoever wants to exclude it to say so clearly. That is not a ruling about whether guns should be more or less present in daily life. It is a ruling about who has to speak up first when nobody has spoken at all, and the court came down decisively on one side of that question. It is also worth remembering how quickly this area of law has moved. Bruen came down in 2022. States spent the following years testing exactly how far they could push new restrictions within that framework, and Wolford versus Lopez shows the court is still actively policing that boundary 4 years later, with real, specific consequences for how an ordinary business or an ordinary permit holder operates on any given afternoon. One more thing worth sitting with before we close this out. Rulings like Wolford versus Lopez rarely get the attention they deserve, because they do not sound as dramatic as a headline claiming an entire category of gun laws vanished overnight. But the actual mechanism this ruling changes, who bears the burden of speaking up when the law is otherwise silent, ends up affecting far more day-to-day interactions than a splashier, more sweeping ruling might. Every single day, permit holders in Hawaii walk into businesses without giving it a second thought, and every single day, business owners open their doors without posting anything about firearms policy at all. Wolford versus Lopez touches every one of those ordinary moments, quietly, and that is exactly why understanding it accurately matters more than reacting to the headline version. If this finally explained what actually happened in Hawaii, instead of the vague 9-0 style panic headlines floating around right now, hit that like button so more people find the accurate version instead of the noise. Subscribe, because this reasoning is going to keep resurfacing as other states get tested over the coming months, and I will break down every single one the moment it drops. Comment your state below and I will tell you honestly whether your local rule looks like it survives this same test or not.